Just give folks a minute to join us. Thanks for those of you who are already joining. We'll get started here shortly. All right, well, it is 11 o'clock, so I'd like to get going today. Good morning. I'm Sarah Miller, Vice President of Marketing and Strategic Communications for the Small Business Association of Michigan. And I'm happy to introduce our presenters today joining us from the American Arbitration Association. We have two guests with us. First, Bridget McCormack became President and Chief Executive Officer of the AAA in February of 2023. Bringing her broad and deep experience in dispute resolution from her judicial, advocacy, and academic careers. Bridget served most recently as Chief Justice of the Michigan Supreme Court, deciding thousands of cases and overseeing the courts throughout the state. And joining Bridget is Svetlana Gitman, Vice President, Commercial Division of the AAA, where she administers large, complex commercial cases, manages the panel of commercial arbitrators, and directs outreach efforts for their mission and services. So thank you both for joining us today. Before we begin, a few housekeeping notes. I will be monitoring the chat for questions, so feel free to drop them there. And we will share this recording and our slides with attendees following the event. So again, thank you to Bridget and Svetlana for joining us today. I'll turn it over to you.
Thanks, Sarah. It's great to be here. And it's always really wonderful to visit with the Small Business Association of Michigan, which I've told Svetlana a lot about. It's the best association out there for small businesses, and the work that you all do to support one another is impressive. And I'm really glad that Michigan has you in it. I always enjoyed talking to you about what the court was doing when I was serving on the Michigan Supreme Court. And I explained that the Supreme Court has administrative oversight of all the courts of the state. And that means that how people can get legal help is and was an ongoing concern of ours at the Michigan Supreme Court. And you've heard me talk about the large number of people and also businesses that can't afford legal help. In the United States, somewhere between 85 and 91% of people can't afford legal help with most of their civil justice problems. And that's also true of most small and medium businesses. They are priced out of the market. And that is fine until something goes wrong, and then it's less fine. The American Arbitration Association is a nonprofit that focuses on giving businesses and others tools to resolve disputes efficiently, effectively, privately, so that you can avoid the disruption of what happens in courts sometimes. And I am delighted to have Svetlana here to talk in broad terms about what we do with some specific ideas and resources that we think would be useful to you and the rest of your members. So we're delighted to be here. Svetlana is a superstar. She's one of our vice presidents and a future leader of our business. And I'm going to turn it over to her now.
Thank you so much, Bridget, and thank you, Sarah, for having us. So I will share my screen so I've prepared some slides to help us guide through today's presentation. So we have quite a few things that we wanted to cover with you today. So I put together a little agenda and we will follow it as best as we can. We'll start today by talking about what is the American Arbitration Association. You'll hear us say AAA a lot. We're referring to the American Arbitration Association, which often gets confused with the other AAA, the Automobile Association of America. So we do get some of their phone calls here, and I have to politely usually tell them, like, no, I don't need to be an additional insured or anything like that. But you'll find that there are some acronyms, so we'll define them so you know what we're talking about. Once you learn a little bit more about the AAA, we will talk more broadly about what is alternative dispute resolution, sometimes known as ADR. And specifically, one specific process, arbitration. Arbitration is a type of ADR process. We'll then dispel some of the myths that you might hear about arbitration in the news or through your business activities. And then we'll end by highlighting why arbitration might be right for you and providing you with AAA resources for you to use if you are interested in the ADR process and think it's a good match for your business needs. So with that, let's get started. Part one, what is the AAA? This is what the AAA looked like back in 1926. It was a merger of two early organizations, the Arbitration Society of America and the Arbitration Foundation. This is not what the AAA looks like today, I promise you that. And more concretely, the AAA was created in 1926 in response to the Federal Arbitration Act, which was basically a law allowing parties to settle their disputes outside of court. As you heard Bridget say a minute ago, we are a nonprofit organization, and we basically act as a third-party neutral to help parties resolve claims by administering cases based on our rules. We're headquartered in New York with 26 offices nationwide, and we also have an office in Singapore. Since 1926, we've administered over 7.6 million cases, and just from January 1st of this year to today, we've resolved 270,000 cases. So we're quite busy. We maintain a roster of approximately 6,000 arbitrators and 1,100 mediators. And we'll talk in a few minutes about what exactly an arbitrator is and what is a mediator. And our goal is to provide ADR services in all different areas. Today, we'll be talking about commercial disputes, but we also provide services in construction, consumer, labor and employment, international. We also administer elections, and we've often been called upon in times of need by governments to help resolve disputes from national relief programs, like such as Hurricane Katrina or Superstorm Sandy. So I kind of told you the basics, but these are the fun things that most people don't know about the AAA. And now you will know in case you're ever, find yourself in a game of AAA pub quiz or trivia. The first president back in 1926, Bridget's our president now, but back in 1926, it was the president of GE. It was Thomas Burchard, our very first president. Boris Karloff, who you might know as the lovable monster Frankenstein, served as one of our arbitrators in 1956. Our smallest commercial award rendered in history was 6 cents, and that was awarded to Bob Fosse, who some of you may know, I'm kind of showing my age, choreographer, dancer, and director of cabaret. More substantively, we are the largest ADR provider in the world. And what we're most proud of is the work that our AAA ICDR Foundation does. ICDR is an acronym for our international branch of the AAA. Together, our foundation has provided over $8 million in funding to charitable projects all over the world that are using ADR principles to effectuate change in their local communities. So now you know about the AAA. What is ADR? Another acronym we're going to talk about today. It's basically alternative means of dispute resolution. So alternative to court that can save time and money and can help you put disputes behind you while preserving valuable business relationships. It's inevitable that at some point a dispute may arise. It might be that a party that you have a contract with doesn't do something they agreed to do, or maybe they're claiming that you didn't do something that you agreed to do. And so a dispute will arise, and think of ADR as a mechanism for resolving that dispute quickly and moving past it, which is especially important if you want to have a continuing business relationship. You just need that one small dispute resolved. I kind of wanted to give you more of a graphic about what types of dispute resolution ADR there is. So on the left side, we have lawsuits. So that's not ADR, that's litigation. But everything to the right of that are all different ADR, alternative dispute resolution mechanisms. Today, we're going to talk about arbitration and a little bit about mediation, but there's a wide variety of things you can attempt to resolve the dispute rather than just going straight to court. So why might small businesses, or why should they consider ADR and avoid litigation? Saving time, which in effect saves money. Avoiding publicity. ADR is usually confidential, specifically arbitration is confidential. So if business reputation is important to you and you don't want everyone knowing that there's a lawsuit against you or you're suing someone, confidentiality can be important. Once you file something in court, it's out there to be discovered by anyone in this world. You also get more control over the process. Arbitration is a party-driven process. The parties get to give input into selecting who their arbitrator will be, selecting how their schedule will work. So it's more control over the process rather than just kind of following what the court has prescribed. And again, I mentioned this because it's really important, but the desire to preserve ongoing business relationships. It's hard to continue doing business together when you've litigated against each other for years, but when you've amicably used an ADR process to resolve your dispute quickly, there's more opportunities to move on and continue that business relationship. Part 3, see, we're moving along just well. What is arbitration? I know you're wondering why a picture of George Washington here. He did not create arbitration. He was not a founding father of arbitration, but he did have an arbitration clause in his will. In 1799, his will called for arbitration to resolve disputes among his heirs. So clearly, George did not want any dirty laundry being publicized to the public. He wanted the confidentiality aspect of arbitration. So what is an arbitration? So an arbitration usually starts with an agreement. It begins when parties previously agreed in a contract to resolve any dispute through arbitration instead of going to court. And this is often called arbitration clause. If there's no prior agreement in a contract, parties can still agree to arbitrate their dispute. So it doesn't mean they have to go to court. They can agree to still submit it to arbitration for the reasons we just talked about. Once the arbitration is started, the parties then choose an arbitrator who will most often be an expert in their field. And when I say expert, I really mean expert. I've administered cases where we had to have somebody familiar with the bean industry, liquid egg industry, and we found those people. So when you go to court, you don't really know what judge you're going to be assigned to, and you don't really know if that judge will have expertise in that area. In arbitration, you have more input into selecting your neutral, and an administrator like us at the AAA, we can help you find that expertise. Once we have an arbitrator, then we move on to the presentation of the case. Each party will present their case to the arbitrator, and this usually involves submitting documents, maybe oral testimony, maybe witness testimony. But what's important to remember is that the process is much less formal than trial. Because it's much less formal, it could be quicker and therefore, very importantly, cheaper. For example, in court, you have to follow the rules of evidence, which can sometimes be burdensome and require extra steps that can drive up the cost. Arbitration is much more relaxed and therefore can be a good option, especially if costs are important. So once the evidence is presented, then you'll get a decision from the arbitrator. After the hearing, and you as the parties get to decide how the evidence will be presented as we discussed, the arbitrator will make a decision, and that decision is often known as the award. The award is usually is final and binding, which means that it could be taken to court and enforced if one side is not following what the award ordered. So that's kind of an overview of the process. What's important to also remember is that this decision usually comes really quickly after the presentation of the evidence. It's either 14 days or 30 days. So you are not going to be waiting months to get a decision from the arbitrator. So just as a recap, we kind of gave you an overall what to expect. But as a recap, how does a case get to arbitration? So usually there's that dispute clause in the contract, or after the dispute arises, the parties agree to submit it to arbitration because they recognize the benefits rather than going to court. We have this wonderful graphic that kind of shows you the life of a case. We have it available online at adr.org in a much larger size, in a larger version for those of you who are like me and cannot see tiny font that well anymore. But to give you a recap of what each stage is, the first 2 weeks where we talk about filing and initiation is basically where the AAA receives the case, it assigns it to a case manager, and completes any other administrative tasks that we need to do. The next stage is the arbitrator selection process. Now, this phase can be as quick as one day, or it could last a week or so. If the parties are working together and they have agreed upon an arbitrator, then the AAA will appoint that arbitrator that they've agreed on. If the parties are not able to agree on an arbitrator, we either look to see what their clause in their contract, if they had an arbitration clause, says about arbitrator appointment, or we follow our rules. And the default method for our rules is usually we make you a list of 10 or 15 arbitrators. Each side crosses out who they don't want, ranks the remainder, sends it back to us. We reconcile it, and then the highest ranked arbitrator is the one that's appointed. So that could take a week or two. Once the arbitrator is appointed, you will have a call with the arbitrator, and this could be by video, it could be by phone, whatever is most convenient for the parties. And on that call, the arbitrator and the parties will design a schedule for that case. You'll talk about the type of information you need to exchange, if either side needs something from the other side, how that you want the hearing to look. Is it going to be in person? Is it going to be virtual? Things like that. And once the schedule is entered, then the parties begin exchanging information. That's that period here in the middle. They exchange information, and if at that point they might consider going to mediation. So that's another ADR process that we'll talk about. It's a little bit different than arbitration. In a mediation, the mediator is not going to be making a binding decision like the arbitrator. The goal of mediation is basically to help the parties reach an agreement, but the mediator doesn't really issue a decision that is binding on everyone. If the parties choose not to do a mediation or it's not successful, then the next step would be to go to a hearing. That's where the parties will present their evidence, like I talked about earlier. Now, the timeline, and once the hearing is closed, then the award will come out. If there's any reason to submit post-hearing documents, the schedule will provide for that, and then the award will come out 14 or 30 days after this. Now, this is the timeline here for a case for what we call a regular track. So a case that would be over $100,000. That would last about 9 months. For cases that are under $100,000, the timeline is much more expedited. And by much more, I mean 2 to 3 months. That's how long it lasts. So this exchange period and everything else is truncated by a lot. And the award comes out in 14 days. The other benefit for our expedited procedure in cases that are $100,000 and under is that you will know the exact cost of this whole process for you. I wouldn't say it's a bad thing, but one of the differences between arbitration and litigation is when you go to court, you're not paying for the judge's time, right? In a private process, you are paying for the arbitrator's time. And so they have an hourly rate. In these expedited cases, they do not charge an hourly rate. They have a stipend. And for cases under $100,000, the rate for the arbitrator is $1,300, $1,350 actually. So you know upfront exactly the cost that it will cost for both sides for the arbitrator's time, which is very limited. So again, kind of reasons that I've touched on most of these reasons with the graphic that we just saw, but here are the big reasons why you might want to choose arbitration over litigation: cost effectiveness, time efficiency. And I probably should have put time efficiency first. Time efficiency leads to cost efficiency. Simplicity and then flexibility of the process. Like I said, you can agree to do your hearing virtually. You'd be surprised how much faster schedules align that way, and the reduced cost. You don't have to travel somewhere. Maybe your business partners don't have to travel, take time off of work. They could just do it from their office. The expertise, again, you get to have input into selecting your neutral. So you are getting the person with the expertise that you want. Confidentiality, Reputation can be very, very important. And then finality. And finality is important in terms of cost as well. When you are in court, and once one party doesn't like the final decision or the verdict, there's an opportunity for appeal. And there's actually there could be opportunities for multiple layers of appeal. And that will all take time and that will all take money. One of the highlights of arbitration is that the award is usually final. And so that saves time and cost in that sense as well. So now we come to the good part. Let's dispel some of the myths that you might have heard about arbitration. So ad hoc arbitration is cheaper than administered arbitration. And I'll start by explaining what these terms mean. Ad hoc arbitration is basically where the parties agree that, yes, we don't want to go to court. We want a private mediator to settle this for us, but we don't want an administrator. We don't want to go through an organization like the AAA. We just want the arbitrator to handle everything. So the arbitrator is going to not only decide the legal issues, but they're also going to take care of all the administrative tasks, the finances, and deal with any conflicts of interest or things like that. Whereas administered arbitration is for someone like the AAA to be a third-party neutral and take care of the administrative tasks, the procedural issues before the arbitrator is appointed, the finances, to kind of let the arbitrator focus on just the legal issues. And so what are the arguments for this ad hoc arbitration? It avoids upfront administrative fees that you might have to pay to an organization like the AAA. Many arbitrators will agree to take these ad hoc cases. They'll say, fine, I will administer this myself, even though they're oftentimes not supposed to, especially if the clause says that the AAA needs to administer these cases. We know it still happens because once in a while, or more than I'd like to think about, I do get calls from parties saying, hey, we have a AAA arbitration and we just think there's a problem with the arbitrator. And I'll be like, oh, I'm so sorry to hear that. What is the case number so we can look into this? And I'll be like, oh, but you're not administering it. And I'd say, I'm so sorry, there's really nothing we could do if we are not administering. We don't kind of have that oversight. So that's the issue with ad hoc arbitration. And so I talk about these hidden costs of being really careful about just kind of hiring somebody to do your arbitration, because you can have uncomfortable situations with that decision maker. For example, if something arises that you think might be a conflict and you think, they shouldn't be serving on your case anymore, you have to raise it to them, which could be a really awkward conversation to have, right? Oh, dear arbitrator, I don't think you're fair. Can you step down? They're probably not going to say, oh, you're right, I'm not fair. They're going to tell you, no, I can keep continuing to serve on this case. Whereas if you have an administrator, the administrator will take care of all of that behind the scenes. They'll take care of all the finances, things like that, so that you don't have to have those uncomfortable conversations. And more importantly, they'll make sure that the case keeps moving. We have a very sophisticated case management system that our cases move along in a very speedy manner. If somebody's not getting some documents in, we have reminders going out. So you don't have this fear of the arbitrator kind of just forgetting about your case and getting to it when they have time, because we know your cases are important to you. You want them resolved as soon as possible. So that's one thing I like to say, that, you think you might be saving costs by not using an administrator, but in reality, here's the percentage of costs an administrator like the AAA, specifically the AAA is. It's 5% of the overall cost of the administration. Of total cost of the arbitration. So it's quite small. So I say, think about using an administrator as an insurance policy to make sure that your claim gets resolved in the best way possible. Another one, arbitration takes as long as litigation. False, not true at all. And we know that because we have the numbers. We look at the numbers every year. We compare the numbers of the median time from filing to trial for the federal U.S. district courts and with the AAA. So currently for 2022, the average for U.S. district courts was 33.2 months. And I think Bridget will agree with me that state courts can oftentimes take longer than federal courts because they're busier. They have more cases to get through. So you can only imagine what a state court number could be. But here at the AAA, our average number is 13.2 months. And specifically, I took a look at Michigan cases, so slightly over that with 14.4. So 14.4 versus 33.2 is a lot faster. So that myth is just very untrue, and I'm here to tell you how. Mediation. Mediation is not available if you file an arbitration demand. You already know that's not true because we talked about the timeline. In fact, why don't I pause for a second and tell you what mediation really is? So mediation is an informal negotiation assisted by a third party neutral, who you're going to call the mediator, that encourages the disputing parties to craft their own solutions. And because of that, it enhances the likelihood of continuing that business relationship. I know I keep talking about it, but the feedback we get from our users as to why they really enjoyed the arbitration process is that ongoing relationship that they were able to maintain with the party they were disputing with. That was very, very important to them. And so we recognize that at the AAA, and in fact, AAA rules, those rules I told you that we follow to administer the case, they encourage mediation. Any case that's over $100,000 requires the parties to go through a mediation unless one side opts out. But the mediation can be done at any time. It could be done before the arbitration. It could be done during the arbitration. The mediator is typically a different person than the arbitrator. We typically don't want them to be the same person because sometimes you're willing to share some information with the mediator that maybe you don't want to share with the arbitrator. But I will say this, many times the mediation does settle the case or at least narrows down the issues, which is important because that means you'll have less issues for the hearing, which will again save on time and save on cost, which is very important. We have this special program designed at the AAA. It's called the Fixed Rate Mediation Program, and I think it's really wonderful. What it is basically it's a program designed for parties whose claims are $100,000 or less. There is a filing fee of $300, and the mediator's compensation is capped at $600 per side. For that, which I'm not great at math, but I think each party would pay $750. Bridget, please check me on that. You will get a full day of a mediator's attention, and you will have that mediation set up within 30 days of when that mediator is appointed. So it's a wonderful way to see if you can resolve the dispute before taking on a more formal process like arbitration. I'm always surprised by the parties being surprised at the fact that they resolved their dispute through mediation without having to take that next step to arbitration. So I'd be happy to provide more information about this program for anyone who's interested. And part 5, so we're coming close to the end, but why AAA arbitration might be right for you. So we talked about kind of the different types of cases. This expedited procedure is really great and valuable for cases that are under $100,000. We have reduced administrative fees. So you know how I told you a lot of people complain about the upfront administrative fees, where they're quite small on the expedited cases. It's $925. And like I told you, the arbitrator's compensation is $1,350. If the case, and I'll tell you this, most of our cases do settle before the evidentiary hearing. They don't make it to the evidentiary hearing. If the case settles before the evidentiary hearing, this is the total cost that you will incur to have the dispute resolved, and in just 2 to 3 months. So if you think about that versus being in court for years, having to have legal counsel in court for years, it's a huge cost saving approach. You'll also get the award in 14 days. I dare you to find anyone that's going to give it to you quicker than that. 14 days, that's 2 weeks. But that's not all we can do. And that's not all the different tracks that are available for you. So what happens when your case is larger than $100,000? And specifically, what if you have a very large case? We also have a cost saving opportunity on the bigger cases called the streamlined panel option, where oftentimes with bigger cases, the parties want 3 arbitrators. It seems like a good idea to them at the time for some reason, but I always tell them, 3 arbitrators is not just 3 times the cost, it's more like 5 times the cost of 1 arbitrator, because not only do 3 people listen to everything that you say, but they also have to deliberate with each other. So we've also developed a program where one of the arbitrators kind of serves as the chair and does all of the main work until the hearing, where then you have the whole panel. So it will save a lot on the cost getting up to the time of the evidentiary hearing. We also listen to our users. We're one of the first, I think we are the first provider to have an alternative fee arrangement in single arbitrator cases. Other industries have it, so we thought we should have it as well. And there's basically a fixed fee arrangement where the parties can select an arbitrator and agree on an overall fee for the case. They'll kind of divide it as to like, we want this period, we want this many hours on this phase, this many hours on this phase, and the arbitrator can, kind of agree to accept that proposal or not. And similar with the capped fee arrangement, the parties and the arbitrator agree to a maximum fee for the entire process, and then the arbitrator kind of bills their time in accordance with that. So we are very aware of the fact that legal services are increasing in cost. And so we're very cognizant and always thinking of new ways to make the process more affordable for parties. Some other benefits that might not jump out at you as much, but the ADR process really helps further diversity initiatives. The legal field in general struggles with diversity. It's unfortunately one of the least diverse professions in this country, but the AAA is committed to the growth of diversity, equity, and inclusion. And we believe that individuals that serve as neutrals who have diverse backgrounds and experiences make better decisions and increase the public trust in the process as well. And so we continue to recruit diverse arbitrators. In fact, for the past 2 years, close to 50% of the newly added arbitrators to our roster are diverse individuals. And I can happily report to you that 30% of our entire panel is diverse individuals. And last year, 36% of the appointments were diverse individuals. So, we're really paying close attention to that. We're also a signatory to something called the Rate Corollary, which is an initiative to increase the number of diverse persons selected as arbitrators and mediators. That's one thing, again, that parties are able to have an input when selecting a neutral. You don't get that opportunity in court. You usually just get assigned to a judge. But here, if it's important that, your neutral is a diverse person that maybe you can relate to more, you feel will understand your claim better, you will have input into that selection process. What else? ESG protocols. So we are a signatory to the Greener Arbitration Pledge. And basically, we've developed different mechanisms to reduce the printing of paper. We've developed online hearing exhibits to reduce those kind of environmental hazards that we are trying to contain. Cybersecurity. So we want to keep your information safe. We're constantly providing training to our staff and our arbitrators and best practices to our users on how to make your information safe and best practices in that realm. And we also embrace technology. When the pandemic happened, we felt no interruption. We were able to pivot right away because a lot of what we had been doing was already virtual. And so we now offer that same flexibility to our users. You can have your hearing virtually so that many people don't have to travel in, and that reduces cost. So these are some of the reasons that might not jump out at you right away, but definitely important to consider. And I see we have a question, so I'm going to take a look at what it is. Who pays for the administrative and arbitrator fees for less than $100,000 cases? The one request, or is it shared by both parties? Great question. So the party typically is the one paying for the administrative fees. So the claimant, so the party that first files the arbitration demand will be the one that pays the arbitration fee. Thank you for that question. That was a good one. So in summary, we've talked a lot about AAA arbitration today, but here are kind of things that are important for you to remember. I'm not going to go through them because I think you've kind of heard me talk about them a couple of times now, but we will be sharing these slides with you. So if you need to refer back to them to kind of remind you of the benefits of ADR, please take a look at them and then contact us if you have any further questions. What resources are available? Well, other than Bridget and myself, we do have website resources as well. Here are the two websites I'd really like for you to visit. One is our rules page, which has all of our rules, forms, and our very transparent filing fee schedules. Like I said, it's really important for us to be transparent so that you know what the costs are. We don't really try to hide it in any way. And so we post them up there for you to see. And then the other website is this resources page that will tell you a lot about what we do and also has a lot of helpful guides. One specific thing I wanted to talk to you about is this tool that we've created. It's called Clause Builder. For those of you that think ADR might be a good dispute resolution mechanism and think, hey, maybe I want to include it in my contract and have an arbitration clause, we've created this free wizard. So free, no cost to you. All you have to do is go to the website. It will walk you through how to create an arbitration clause, and then it will actually create it for you. So it will ask you a bunch of questions to get a better understanding of, what industry is this for? What kind of needs does the contract have? So if I show you right here, this is the page that you'll get to. It will start by telling you kind of what the standard clause looks like, but then it will help you to make it more appropriate for your exact business needs. You'll personalize it. It will ask you questions about how many number of arbitrators, the method of the arbitrator selection, and it will give you little bits of information kind of explaining what 1 versus 3 arbitrators would mean, the different methods of arbitrator selection. So you kind of know why you're making those decisions. And then when you go through all of these things, and your clause might not need all of these specific things in it. These are just some ideas to think about as you're drafting your clause. But at the end, it will basically generate a clause for you that you can copy and paste and, make any other changes you need and put it into your contract. And so I told Sarah earlier, if that's something of interest that SBAM would want us to kind of help them look through those clauses or have a workshop about best practices for clause drafting, Bridget and I would be happy to do that, whether it's in person or another webinar. We're happy to give more feedback, but these are kind of the helpful hints that you want to keep in mind when you're thinking about drafting that arbitration clause. And like I said, it's all on that free widget that we have at clausebuilder.org. Sarah, I see you popping on. Do we have another question?
We do. We have a question that just came in, and it reads, do cases associated with EEOC, FMLA, ADA, et cetera, also go through arbitration? And if so, must they go through arbitration if an arbitration agreement was signed? Or can they skip it and go directly to the courts?
So I think what this question is getting to is when do you go through AAA arbitration, and are there other administrative agencies that have their own arbitration process that you have to go that way? So yes. So what we're talking about today is really commercial matters, a business to business commercial matter. And in those situations, the parties have the flexibility to design their own dispute resolution process. When we go outside of the commercial area, there are certain areas that there's administrative agencies that have their own arbitration process. And in those situations, you will be following that. You can't sort of, craft something and say, no, we want to do something different. There's a different path for that. So it just depends on kind of what area you are. And today we're talking about commercial disputes. And so with commercial disputes, you can design your own arbitration clause. Now, if you don't have an arbitration clause in commercial disputes, then your dispute resolution mechanism is to go to litigation. Bridget, anything you want to add on to that?
No, I don't think so. I think you covered it. I think that's exactly right. But if that wasn't exactly what the question was getting at, please feel free to ask again, and we can offer more information.
Definitely. Absolutely. And so again, these are the best, these are kind of tips for drafting an arbitration clause that you want to think about. And then before we end today, I did tell you that we were really proud of the work that our AAA ICDR Foundation does. So I want to tell you a little bit more about that. We are very unique in the ADR provider field in that we are probably one of the only nonprofits. And so what that means is much of the revenue that we make each year gets put into our foundation that we then distribute to charitable organizations all over the world. And the priority areas that we focus on are to prevent and reduce violence, to bridge community conflict, and support diversity, equity, and inclusion. And the reason I mention this is that our annual grant cycle just opened up a few weeks ago. And I know many people who own businesses also sit on nonprofit boards. And so if your nonprofit board might be a good fit for one of our grants, I really encourage you to visit our website and see if this is something that, can help provide funding for those projects that they're working on. And that's it for me. Here is my contact information, my phone number, and my email address. For any questions you have, please feel free to reach out to us. One of my roles as a case manager and an administrator is to answer those questions. And there are no questions that are too small or too silly. This is a new process for most people. It is not like litigation, so don't be bashful about asking questions.
All right. Well, thank you both so much for your time today. I know I learned a lot, and I'm sure our members did too. We appreciate you taking time to share this information with all of us here at SBM.
Thanks so much, Sarah.
Thank you.
All right. Thanks for tuning in today. Everyone have a wonderful day. Bye.
Bye-bye.